Hello, this is Brian Fieser, and my presentation on teacher-free speech or free expression. And then we're going to discuss a couple historical cases that we've already discussed in class and some current ones that are much more recent. So, some legal background. The Tinker case that we've already discussed from 1969 ruled that teachers do not shed their rights at the school gates. Many courts, the Supreme Court included, since then, have ruled that they do, however, shed some rights. In 2006, for example, Garcetti versus Cerebros, the Supreme Court held that public employees' speech is protected by the First Amendment only when that public employee is speaking as a citizen and on a matter of public concern. They are not to be speaking pursuant to his or her duties as an employee. Also note that the employer has a right to balance the interest of an efficient workplace in reference to the comments being made. A more recent case that pertains directly to school would be Brown versus the Chicago Board of Education, noted that a teacher used the N-word in reference to a note that he saw being passed during class time. That note had song lyrics written on it. The teacher used this as a teachable moment to discuss the N-word and its historical ramifications, as well as using the N-word himself. The principal, who was present in the room for part of this discussion, overheard the teacher saying the word. In his post-discussion talks with students in the class, he may have also used the word himself. The result of these talks was the teacher was suspended for 5 days. This had to do with the school's policy that the teacher of the building are never to use racial slurs. Due to the wording of the policy being explicit like that, this teacher was in violation. Because of that, the Seventh Circuit Court held that employees have the right only as a citizen about topics of public concern. The First Amendment provided no protection to the teacher in this case, and circuit courts ruled that it is the teacher's job to speak on the subject that they are expected to teach, as the schools maintain the right to decide curriculum. This would likely only apply to public education schools. It would probably not apply to post-secondary education schools, where there is a history of academic freedom that has been recognized by the Supreme Court. Another recent case, Melnick versus Teaneck Board of Education. This is from November 2016. A New Jersey court held that a teacher's rights were not infringed upon. This was a literacy teacher that was discussing a reading for an approved curriculum, and it in fact was a reading that she had discussed previously in other classes. An African American student found part of the class offensive. This teacher, who was of Dutch descent, was talking about some of her relatives still following the Dutch tradition of dressing up in blackface as the man that accompanies Santa Claus. The teacher showed pictures to students from her personal cell phone during class time of her relatives dressed up in this specific tradition. The teacher tried to explain that it was a cultural difference and not to be confused with the derogatory comments the student was making. The student, however, still filed a harassment claim, and the teacher sued the school claiming that her First Amendment rights had been violated. The district court granted a motion to just dismiss this case. Because the pictures were not part of a public concern, so there'd be no protection granted for First Amendment rights. Speech in this aspect was in reference to the curriculum is not protected, since her comments did not pertain directly to what she was to be teaching. Some notes that we can take from this are that since neither of these cases were in the First Circuit, They would not be binding in Maine. While in school, teacher free speech is limited to the extent is still to be determined. There are reference in this in Chapter 4 as the scope of citizen versus an employee, and the true definition of what is public concern is still being decided by the courts. Consequently, schools would be prudent to address situations involving employee speech, in particular classroom speech about politically or socially important issues, very carefully, and to consult with legal counsel before doing so. Some important distinctions. These are just guidelines and not a guarantee, but some acceptable actions would be a letter written on private time to a publication for or against a topic. It would be acceptable, most likely, to post an online support to a political candidate or movement that is outside of school time and not discussed during the school day. And it would probably be acceptable to attend a rally on the weekend, so long as it is not discussed in great detail with students during said school day. Some potentially unacceptable things would be joking about students on social media about how lazy they are, even if they're not specifically named, discussing with students about the rally you attended over the weekend and ramifications from that, or displaying propaganda for a political candidate or movement, whether it's a t-shirt or poster on your wall, would probably not be acceptable and not held by the courts. So, some implications that teachers should take from this are that schools control the information that is distributed in the curriculum that is going to be taught. What is a matter of public concern is still very debatable. For example, the review process of how it will be decided is not set in stone. And complaining about the school board could be prohibited by the school board in reference to not being a citizen necessarily. Some implications that administrators should take from this is they need to be informed and aware of teacher curriculum. Here in schools like Vinyl Haven, where there's a high turnover rate of teachers and administrators, it would behoove both parties to be aware of what is being discussed and what is being talked about. Administrators should address issues very carefully and consult legal counsel with concerns before drastic actions are taken. And just to be aware that teacher rights are still being determined by the court as in what would and would not be acceptable. So this was Brian Fieser's talk on teacher free speech. Thank you for listening.